If you are a green card holder living in the United States right now, I need you to stop whatever you are doing and pay very close attention to what I'm about to share with you, because what is happening in 2026 could directly impact your status, your business, your travel plans, and in some cases, your ability to stay in this country. These are not rumors. These are not speculations. These are real documented policy level changes that are already taking effect. And the worst thing you can do right now is be caught off guard simply because nobody told you. I have been a green card holder myself, so I understand firsthand how unsettling it can feel when the rules shift beneath your feet without warning. You did everything right. You went through the process, you waited, you filed the paperwork, you followed the law, and now the landscape is changing faster than most people realize. That is exactly why I am here. Not to scare you, but to make sure you walk away from this video informed, prepared, and clear on what steps you need to take. Knowledge is the most powerful tool you have when it comes to protecting your immigration status, and today I am going to give you all of it. Let us start with the very first change. And honestly, this is the one that caught me most off guard when I first came across it. If you are a green card holder and you own any percentage, and I mean any percentage, of a business that is applying for an SBA loan, a small business administration loan, you are no longer eligible. This change went into effect starting March 1st, 2026. And there is no workaround, no exception, and no grace period. It does not matter how long you have held your green card. It does not matter if you have been in this country for 15 years, built your business from the ground up, employed American workers, and paid every single one of your taxes on time. As of March 1st, if you are a lawful permanent resident and not yet a naturalized citizen, the door to SBA financing is closed for you. And let me be clear about why this stings so deeply. Small businesses are the backbone of the American economy. Green card holders who run businesses are contributors. They are taxpayers, they are employers, they did things the right way, and yet this policy effectively creates a ceiling on how far they can grow their business without first becoming a citizen. So if you have been putting off your naturalization application and you are already eligible, this is your sign. The time to act is right now, because citizenship is the only thing that removes this barrier entirely. The second major change involves something that affects every single green card holder who is either renewing their card or applying for citizenship. And that is the significantly increased level of background checks and medical screenings now being required during these processes. When you file your I-90 to renew your green card, or when you file your N-400 to apply for naturalization, USCIS is now conducting far more thorough investigations into your history than they ever have before. We are talking about a deep dive, arrests, prior visa applications, previous marriages, any inconsistencies in your immigration paperwork going all the way back to when you first entered the country. If something in your history even looks like fraud, even if it was a minor discrepancy from years ago, it can now be used as grounds to deny your green card renewal or flag your naturalization application. This means that the N-400, the naturalization application, is no longer just a step forward towards citizenship. Under the current environment, it has essentially become a second opportunity for immigration authorities to look back at your entire history and scrutinize it all over again. That is not said to discourage you from applying, quite the opposite. But what it does mean is that you cannot just fill out that form casually and drop it in the mail. You need to review your entire immigration history before you submit anything. You need to know what is in your record, and if there is anything, even the smallest thing, and that gives you pause or makes you even slightly uncertain, please do yourself a favor and schedule a consultation with an immigration attorney before you file. One consultation could save you from a denial that follows you for years. Now let us talk about number 3, and this one is affecting green card holders every single time they step on a plane: travel. For the first time in the history of this country, biometric data, including photographs, is now being collected from green card holders both when they enter the United States and when they leave. Every arrival, every departure, it is all being logged, time-stamped, and stored in a system that is more sophisticated and more meticulous than anything that has existed before. And before you think this is just a security formality, let me explain why this directly threatens the green card status of thousands of people who thought they were operating within the rules. As a lawful permanent resident, you are required to maintain the United States as your primary place of residence. The general rule most people know is that you cannot stay outside the country for more than 6 months at a time without raising serious red flags. But here's what a lot of green card holders have been doing for years. And I say this with full understanding because life is complicated. Businesses exist overseas. Families are spread across the world. Many people have been traveling in and out strategically, spending a few months here, a few months there, trying to reset the clock and maintain the appearance of residency without actually being present for the required time. That strategy is now essentially over. The new biometric tracking system calculates your time in and out of the country with precision. There is no more guessing, no more gray area, no more benefit of the doubt at the port of entry. If the data shows that you have spent more than 6 months outside the United States within a given year, you will be stopped, questioned, and your residency will be challenged on the spot. And if you have been outside the country for more than a year without the proper documentation, specifically a re-entry permit, your green card can now be deemed abandoned, not suspended, not flagged for review. Abandoned, gone. And recovering from that is an entirely different legal battle that most people are not prepared to fight. So if you have family abroad, if you run a business internationally, if you are caring for an elderly parent in another country, you need to sit down right now and map out your travel history and your future plans with the understanding that every single day outside the United States is being counted. The fourth change is one that specifically impacts refugees, and it is perhaps the most alarming from a humanitarian standpoint. Under existing law, refugees who are admitted into the United States are permitted to apply for their green card after 1 year of continuous presence in the country. That law has not changed. But what has changed, based on a recent Department of Homeland Security memo, is what happens during that application process. Instead of moving through the standard green card application workflow, refugees are now being subjected to detention for rescreening before their green card is issued. And the most deeply troubling part of this is that authorities are now stating they have the ability to detain refugees indefinitely without bond while this rescreening takes place. That means a person who entered this country legally, was accepted as a refugee, spent a full year here building a life, and then followed the law by applying for their green card, can now be detained with no guaranteed timeline for release while the government re-examines their case from the beginning. If you or someone you know is in refugee status and approaching that 1 year mark, the guidance right now is to be fully prepared, understand your history inside and out, and if there is any complexity in your case whatsoever, seek legal counsel before you submit that application. And finally, number 5, conditional green card holders. This category of green card holders has always faced a higher level of scrutiny than permanent residents with full 10-year cards. But what is happening now in 2026 has taken that scrutiny to an entirely new level. Whether your conditional green card came through marriage or through an EB-5 investment, the vetting process for removing conditions has become significantly more invasive and hands-on. For marriage-based conditional residents specifically, officers are now physically showing up at your home address to verify that you and your spouse are actually living together, and at your place of employment to verify that the information you provided on your application is accurate and current. This is no longer a paperwork exercise where you submit documents and wait for approval. This is active, on-the-ground investigation. Every detail of your life as a conditional resident is now subject to real-world verification, and any inconsistency between what you submitted and what they find can result in serious consequences for your status. The bottom line is this: 2026 is not the year to be passive about your green card. Whether you are renewing, traveling, running a business, coming up on your conditional period, or sitting in refugee status, the rules have changed and the enforcement has intensified. The single most important thing you can do right now is be proactive. Know your record, know your travel history, know your deadlines. And if citizenship is within your reach, move toward it with urgency, because it is the only status that puts all of these concerns permanently behind you. Share this with every green card holder you know, because the people who get hurt by these changes are almost always the ones who simply did not know in time.